There's this school of thought that because she gives certain rulings, some political divide is against her. There's another school of thought which thinks that this is a purely constitutional matter. So far as I'm concerned, when citizens of the Republic feel aggrieved and ask for the Chief Justice to be removed, they have only one method to go through, and that is an Article 146 consideration. That Article 146 consideration can never be immune from imperfections. And that's why we're having this debate.
So in as much as we have grown, per your own statement,
that's
from
correct.
The 1960 Constitution
Yes.
to now, you
Yes.
still believe that the current 1992 Constitution, yes, we've grown, could still have issues.
Every constitution has imperfections, and that's why the robust nature of a democratic system allows the constitution or institutions set up under the constitution to be tested effectively in courts.
And I'll let you continue with your understanding of the Article 146 that we are certainly going to go into,
Right.
and how you think it is being tested now, because this is the first time we are using it.
Right.
Let me take you back to a statement you made earlier.
Yes.
That there are a number of schools of thoughts
Yes.
that say that perhaps she's going through this because of rulings that she's delivered on certain cases.
Correct.
Where do you stand on those?
I beg no opinion on that.
Why?
Because you cannot stop people from thinking the way they want to think. At the end of the day, you have to approach matters in an objective way. I cannot, for purposes of the law, be concerned about the subjective thoughts of people when the objective standard of an Article 146 procedure is prevalent.
So, for instance,
Yes.
one of the things that, or one of the main cases that a lot of people refer to has to do with Parliament. And the fact that the Speaker of the House said that 4 individuals had said they were not interested in the party they originally belonged to.
Yes.
And per the Constitution, the Speaker interpreted it, or I shouldn't say he interpreted, because he doesn't have the power to interpret the Constitution. The judiciary, he took the position, yes, he took the position that those individuals had decided to let go of their seats, and therefore there had to be exactly, the seats were vacant, and the Chief Justice decided to come in and say that, well, the Constitution gave the Supreme Court the power to interpret, and people felt that it was a direct confrontation of the judiciary and a clear interference of another arm of government. Whilst when the LGBTQ bill was passed, she didn't do anything about it when the Attorney General wrote to the Clerk of Parliament that don't even bring it to the presidency.
The comparatives are not necessarily an ingredient for impeachment. Those comparatives are not necessarily an ingredient for impeachment. We go to court on every occasion and we get rulings against us. I disagree with the Chief Justice in respect of a ruling when there was an ex parte application, and the application was granted to run till the end of the case. I disagreed with her. But those are not ingredients for impeachment, because judges have the power to go right and have the power to go wrong. We go to court sometimes to put forward very good cases, we lose. You may complain in the comfort of your office, but that does not necessarily become an ingredient for an impeachment process.
So on the Parliament one?
On the Parliament one, with respect to the Speaker back being
yes, yes.
The Chief Justice took a position in court, which I disagree with, especially in respect to the application for injunction. I disagree that it was held ex parte. I thought there was substantial time for people to have been put on notice. I thought that it was unnecessary for the court to be engaged in an existing confrontation with Parliament, especially as we approach an election period. It gave us very, very tense situation to the environment, the political environment at that time. But that is not to say that these are ingredients for impeachment.
So you agreed that it was an interference?
I wouldn't say it was an interference. It was a constitutional interpretation which did not favor the parliamentary branch of government. I wouldn't call it an interference. Otherwise, persons who do not disagree with the decision to form an Attorney General or J.H. Mensah will call it an interference. Ever since the days of Marbury and Madison, we've come to understand that the Supreme Court is the court vested with power to interpret matters, acts, and everything that comes from Parliament. So it's not an interference. But back to your question as to how people view this, I take the firm position that persons who are aggrieved and want the Chief Justice removed, irrespective of their motivations, will have to trigger an Article 146 proceeding. It is how those who look at the proceeding and those who handle the proceeding, that is what matters for me.
And I would want to proceed quickly to the Article 146, but I still want to get your final thoughts, asking you one more time, that you disagreed with perhaps how she went about the Parliament thing. So would you say that she was wrong?
As a matter of fact, I do not like to say to a learned person or a person that the person was wrong, especially when they are my elders and betters. I will say that their appreciation of the position was not consistent with the settled practice. It's quite a bold and audacious statement to say to your elders and betters that they are wrong. It is much more polite from where I come from to say that the appreciation of the Lord was not in accordance with the settled practice. That's the way we behave, because sometimes your thinking or your dissenting thinking can be the intelligence of a future day. So I do not like to condemn other legal work as being wrong.
Having made that point,
Yes.
And once again, just before I go to the interpretation,
Yes.
would you say there are those who think that, and that's something that you've said, that there are schools of thoughts regarding how she's handled matters, and others are concluding that perhaps what we're seeing now, she brought them upon herself with her own actions and inactions?
I don't believe in that she's brought anything upon herself. I think that those who have brought the petitions have their own reasons for bringing a petition. Every day in and out as we walk the streets of this republic, people make complaints against us, sometimes on their lips, sometimes on the soft part of their minds. If they had a venue to ventilate this, they'll bring it against you. When a judge sits and gives decisions, she has rendered the decision. As to how you decide to look at it, it's not a matter of the judge bringing it upon herself or himself, but the judges will be caged. But as I keep on saying to you, those are not the things. Let me just move very straightforward to a point. We've had this constitution for 25 years and more, if not 33 years for that matter.
From 1993?
25 plus 33 is how, 33 years. Now, we have a situation where I would have thought that by now, and perhaps this case should teach us a lesson, that there's a need for a constitutional instrument to regulate the removal of the Chief Justice so that we know what pertains in the procedure. I'll give an example. When it comes to the removal of the president under the Constitution, for example, all the persons, for example, that are constituted by the Chief Justice, so as the formation of the prima facie case before the recommendation to Parliament, are lawyers, are people learned in the law before they become judges. Unfortunately, our Constitution says that the removal of the Chief Justice is by 2 justices of the Superior Court of Judicature, i.e. the Supreme Court, and then 3 non-lawyers. Now, these persons are not learned in the law. So we have such a serious situation where the judges who are sitting on this have to grapple with the fact that the 3 of them, their decision can trump or overturn the decision of the 2 learned judges. That's a critical omission for me. That's a crucial deficit for me in our constitutional tapestry. That you appear before a committee where the leaders of it is chaired by a lawyer who has become a judge at that. Judge who has been there delivering fine opinions. And then suddenly that judge now perhaps has to subsume his thoughts or his independence of thought to a 3-member team which is not learned in the law. That's a crucial thing for me for purposes of this impeachment proceeding. And it's dangerous for our democracy because you can't expect, for example, cabinets to review the work of a doctor.
Okay, so let me read again to you Article 146, I beg your pardon, which we're dealing with now. And it's up to, I believe, 9. Oh, no, it's up to 11.
Yes.
And I think what we are interested in starts from 6. So I'll read from 6, which says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers.
Yes.
7 says the committee appointed under clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. 8. All proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. 9. The President shall in each case act in accordance with the recommendations of the committee. 10. Where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice, which has been done in this case already. in the case of any other justice of a superior court or of a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. And then 11, the president may at any time revoke a suspension under this article. I want to go back to 6 because you said and you emphasized the fact that there are members, 3 individuals who are not lawyers and may not necessarily appreciate the case that we're dealing with. Right. But if you read 6, it says where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State. The Council of State, we know the composition of the Council of State. We have former Chief Justices on the Council of State. We have senior police officers. Currently, we even do have the former IGP Mohammed Al-Hassan on it, and a few other people who have, occupied very important positions. So it presupposes that it is not just about these individuals you mentioned who may not necessarily appreciate the law or the case. You have prominent people the president first and foremost would have consulted with before going through the rest of the process. So why should you have a problem?
I do have a problem, and all of us should have a problem. Because the first part of the president's making a determination that the committee has to be set up, a panel of case has been made, and the committee has to be set up. The Council of State. I am talking about a committee, the 5-man committee, where only 2 of them are lawyers. Let me make this very clear. For purposes of admissibility of evidence, it's a question of law. Admissibility of evidence for any proceedings, especially a quasi-judicial body which decisions affect the liberties of an individual, it's a question of law. How do the 3 members of the committee appreciate the legal aspects of this, so that if, with respect, Justice Palman says that this document is not admissible, Justice Adu says it's not admissible, do the 3 then outvote them? Is that what we're doing? This constitution was written in 1992. I'm not sure that the framers will have done so today, because it is quite clear that in dealing with a matter as serious as this, you cannot have a situation where the people who are not learned in the law are more than those who are learned in the law. It cannot be a proper representation.
I'm happy you talk about the fact that this has been there for at least 25 years and more.
That's right.
You've been a lawyer as well for that long.
That's right.
I mean, yourself and other lawyers, if indeed, yes, it wasn't applied,
yes,
we could have still spoken about it.
I agree with you. I did not. I am speaking about it now.
Why now?
Because the issue has now come up for consideration. I regret I didn't see this point earlier. I regret others may not have seen it, or others have seen it and have not spoken about it, but it was never too late to speak about it. And I think that the consideration of this in the constitutional tapestry is not proper. Doesn't
this give the impression that other people have, for instance, that it looks like we're getting some lawyers wanting to, paint a different picture, that the president should just, let this thing go and just let things be as they should be? And I'm sure you followed the GBA that program where the president spoke and said that she felt like this was more vindictiveness than going through a legal process.
I cannot speak to the president of the Bar Association's position. I don't speak for the Bar
You don't
Association.
agree with her?
I am slow to come to that consideration, because measuring vindictiveness is not an objective standard. I like to be objective. It's quite difficult to measure somebody's vindictiveness, especially when the president is following the constitutional steps. It's the product of that constitutional process that you can begin to assess it. At this stage, maybe because comments have been made, for example, that the Chief Justice should be restored to a position.
And that's one of the points that she made.
The practical implications of it are onerous. In the first place, if the Chief Justice is restored to a position, how does the Chief Justice then preside over the panels and panel the court, and then turn back and then appear before her juniors at the impeachment hearing? It's untidy. It's awfully burdensome. It's not proper. Practically, it doesn't work out that way.
So suspension should be in place?
I'm not saying suspension should be in place. I would have thought that under such circumstances, perhaps the Chief Justice will have taken a leave of absence in that interim period. That is a constitutional process, so that in future, perhaps when it comes up, the Chief Justice will be given the option to, for example, go on a leave of absence. I say this: if the Chief Justice still remains at post, because she is head of the system, it will mean that decisions and matters affecting her will come back to her. And And if the Chief Justice is an active complainant, as we have in this situation, and then she has to come and preside over matters affecting her, because then she'll say that as a matter of constitutional necessity, she has the right to sit on cases, it will jeopardize the trust that people have in the judicial system. So it is better for the Chief Justice to be removed from the arena of conflict at this stage. She could have been on a leave of absence,
which she didn't do.
Well, I do not know whether she was given an opportunity to do, so I cannot speak to that. I will be very factual. I will not assume. The point at stake is that, insofar as I'm concerned, it will be a bit tedious, impractical, to have the Chief Justice come back presently to superintend who? To superintend the justices who have ruled against her now, and then to go back and then empanel with justices to sit in cases affecting her. Will she sit on cases affecting her and say that because of the constitutional necessity she's Chief Justice, she can sit? It will bring a lot of uproar and confusion in the constitutional system.
But would you like to appeal to the conscience of the president? Because I read the 11.
Yes.
Which said that the president at any time can choose to revoke the suspension.
I am sure that the president at any time can choose to revoke the suspension. And perhaps that is a practical arrangement where the Chief Justice is on a leave of absence. But the point at stake is, what is the benefit of the Chief Justice, especially now that she's an active complainant, an active litigant, coming back to sit upstairs? It's quite difficult. Practically, it will not work. It will throw the court into confusion.
So you say that she should have taken a leave of absence?
I'm saying that one of the options which could have been open to her was for her to take a leave of absence. But the Chief Justice cannot be actively carrying out her duties when impeachment proceedings are underway, because if she complains about the process and decides, for example, that she wants to ventilate that grievance in a court of law, it means that she files the process, she empanels the bench, and then she can also decide to sit on her own case. It will leave the sense that justice is not being done properly. Now
she didn't, or the leave of absence wasn't done, and we had the president using his power to suspend her. Provisions in Article 146.
Right.
So whether it was by leave of absence or the president using his power,
she's absent.
She's absent.
Right.
Others feel that perhaps she should have resigned, having made the point that if there was the option for her to take the leave of absence, she should have taken advantage of it. Would you then agree with her that it is not an option to resign in the midst of this?
Well, that's a very important question. To resign is to concede that you will not fight the issue. And generations that will come after us will say that you knew that you couldn't fight the charges made against her. That's why she bowed out honorably. And therefore her position that she will fight till the last drop of sweat on the battlefield is respectable. She's entitled to fight it till the end.
Let me ask you, just moving a little away from the Chief Justice and having to do with the appointment of justices to the Supreme Court. I think that for many years we've had debate on capping and the need for us to ensure that we are not loading our court, as it were, because every president comes and appoints because the Constitution gives them the power to do so. Where do you stand on this?
7 fine minds have been sent to the bench.
Adding to 20, right?
Yes. Unfortunately, by virtue of the political discussion that we have, these persons are now being tainted as yes men, which is unfortunate because that's the consideration. And that's why I say that every constitutional issue comes with a political baggage. But fine minds have been sent. But there is a problem because of the constitutional, the political discussion which takes place. And that's the danger when we introduce politics into an objective consideration. So much happens to these judges. So the imperfections in our system should not be taken as the sole ingredient in measuring the worth of those.
If you say in our system, you mean locally?
Not just locally. The imperfections in the judicial system should not be used as the sole ingredient in measuring the worth of those who command the judicial branch of the Republic. They work under intense pressure, and we should give them a bit of credit for that.
Let me try to understand you better. You're saying that irrespective of the perception that there could be political appointments, Ghanaians and people who are interested in legal stuff should rise above the supposed political perception and believe that those judges, even if they were selected because of political motivations, we should believe that they would rise above those. That's what you're saying.
Judges have been appointed by presidents and have turned around to rule against them. The judges take an oath The judges take an oath to do right by all manner of men. And therefore, to a substantial degree, a judge cannot look at A to B and say is D. Judges have a duty to perform under the Constitution. And to a very large extent, it does not matter who appoints a judge. And I will say this to you. Judges come to the bench with a consideration and orientation of the law. That orientation may be a bag of a bit of politics, a bit of a bag of the environment from which they've come. A judge coming from a Galamsey area is likely to look at a tort action against a Galamsey company in a very different way. A judge coming from a very politically charged environment is likely to look at matters in a different way. And therefore, judges will always have that political landscape of he was appointed by Akuffo Adu, he was appointed by Rawlings, he was appointed by Kufuor. It will always be there. But at the end of the day, judges stand up to the Constitution and perform their duties.
If that was the case, why the interest in presidents to want to appoint judges? Why that? Real interest in appointing judges, if that was the case, aside from filling vacancies.
Because they believe that the judges will see things their way. But I must say to you, judges get onto the bench and disappoint people.
All right, thank you so much. And that will be it for our conversation. And you just watched right there, if you're just joining us, that legal conversation with private legal practitioner, lawyer Kwame Akuffo. And of course, we've talked about varied issues, the ongoing investigations against the suspended Chief Justice Beatrice Adu, and we've also gone into, or we went into the judiciary and the number of judges that are being appointed. Join us again.
And those were excerpts from an interview with my colleague Beatrice Adu and private legal practitioner Kwame Akuffo on matters arising from the issue of the suspended Chief Justice. We'll continue to bring you interviews like this to better explain exactly what's happening and all that you need to know. In the meantime, it's time for you to win some money on Cash Out. If you dial *439#